Thank you very much indeed for that welcome, Ian. It is a great pleasure to be here. It's always a pleasure to come to Bath, which I think is an absolutely wonderful city. I must say that I've been looking forward to this a lot more than I was looking forward to my 2-hour interview yesterday with the lead inspector from Ofsted, who, as Ian said, is currently inspecting the whole of CAFCAS, its operation from top to bottom. It's been an interesting day. I started off this morning. I was very privileged indeed to be present at the address of the German Chancellor, Angela Merkel, to the joint Houses of Parliament. That was really quite an amazing occasion. I can't help feeling that probably her remarks were slightly more keenly anticipated and will probably be more widely reported, probably than mine tonight. But never mind. It is a great pleasure to be here and also to have the Deputy Mayor in the audience as well tonight. I am going to be talking very much, as Ian said, about the child's voice in the family justice system. So I'm not going to be talking about the family justice system as a whole and all the many things that are going on in it. But I'm going to try to explain to you why I think that the voice of the child is so important. So children, of course, are the subject of all family court proceedings, yet often their voice is inaudible or at least hard to hear. And hearing and interpreting the voice of the child is what we do at CAFCAS. With 145,000 children a year to report to family courts about, and with absolutely reduced professional time available to us, our professional task is a challenging one, and I know there are a number of colleagues here in the audience from CAFCAS who I'm sure can attest to that. So what I'm trying to do in this lecture is set out some of the ways which, despite those limitations and the constraints that we operate, we can make sure that the voice of the child is loud enough to be heard. I'm just going to hope my slides... Yes. Right. So, just a quick resume, if I may. I know this will be very familiar to some of you, but perhaps not to all of you, about what we actually do at CAFCAS. There's two things, really. In public law cases, and that obviously is where a local authority makes an application to a family court to become legally responsible for a child, and that's usually as a result of concerns the child has been or is about to be abused or neglected. CAFCAS provides an important guardian role for each child to look after their interests for the duration of the court case. And in private law cases, where parents cannot agree on things like residence, contact, and other things, we advise family courts about what is in the best interest of the child. There's also a number of more specialist roles that we have for smaller groups of cases, things like international cases, child abduction cases, and surrogacy cases. Now, our caseload has increased very considerably over the last few years. So we've had to immerse ourselves in those very complex family situations that Ian was describing quickly and engage with both children and their families as well. And that engagement is often far from straightforward. It's often highly charged for all concerns because the stakes are so high. However, although our involvement is of necessity brief, our aim is to leave a positive and beneficial legacy for as many of the children as we can, a legacy of individual children being safer from the risk of harm as a result of our involvement and being able to grow and develop healthily and experienced improved well-being as a result of our involvement. And even though the trigger of our involvement can be a specific instance of neglect or abuse, it is that emotional aftershock, as I like to call it, that troubles children more. And this in turn means our work, I think, will always be about the emotional safeguarding of vulnerable children. I see that as the essence of what we do. Now, of course, there's usually a healthy conflict between what parents say about their children, particularly older children, and what those same children say about themselves or their parents. And indeed, some conflict and challenge is part of the growing up process. So when CAFCAS expresses concerns about the voice of the child not being heard, it's not about children being challenged or disagreed with, part of normal family life. The voice of the child priority comes into play when a child who is experiencing harm of some description has no means of his or her own to stop that harm taking place. That child needs and deserves help from the child protection system in this country. And Cafcass has two main approaches, either to promote mediation and other forms of dispute resolution through shared approaches to parenting where no harm is taking place, and secondly, to vigorously protect children where parents are harming a child that either cannot stop, will not stop, or indeed have no idea of the harm that they are causing. Many children we work with are in transition, either between one family and another, or increasingly these days actually between one country and another. They're born into a fast-moving, fast-changing and complex world and a personal environment becoming ever more complex. And of course, social media is a key contributing factor to that complexity. Now, all of us in contemporary society face multiple transitions in our lives. Some of them are by choice and others beyond our control. And Anthony Douglas, who's the chief executive of Cafcass in 2012, said that the 21st century brings about what he called the end of stereotyping, with the recognition that every child's case is entirely unique. I know that's not grammatically elegant, but I said that for emphasis, entirely unique, and should be treated as such. A generation ago, resilience was a character trait you were thought to need perhaps sort of 2 or 3 times during critical periods that you might go through in life, if there ever was such a thing as an average life. I think contemporary thinking about resilience, and it's something that I'm involved in other aspects of my work, sees it for many children and young people more as a daily requirement, given that everything that can happen in our 24/7 world. Now, I hope I'm not just stating the obvious when I say that children need a lot of support during complex emotional transitions. And it's heartening to see so much of the positive professional thinking going into this area at the moment. There's models, there's one that's called the secure base model of caregiving, which uses a strengths-based approach for making sense of children's needs and concentrating on helping children to help them achieve their potential. Things like team parenting in foster care and other forms of successful family support interventions. And they all offer a greater prospect of changing the family environment for children than less focused casework. But whatever the professional model, the personality and character of each professional in the team around the child also matters enormously. That's why some social workers never attract complaints. They are able to communicate with warmth, sensitivity and emotional intelligence, even in some of the most hostile and tense situations. So, even though we still don't manage, I think, to measure outcomes very well in the family justice system, the most important outcome, in my view, of the family justice system is to bring about a successful long-term outcome for one individual child after another throughout our 145,000 cases each year. And that has to be our vision, however long it takes us to achieve. If a child is happy and doing well several years on from their court case, partly as a result of the legal framework decided for them, it probably matters less whether they were fully or partially involved in all the hullabaloo of the court process and the case itself. What does matter is that the evidence given about a child by family members and professionals is reliable. Reliable about important facts or events, reliable about what a child needs, and reliable about the best way forward for that child. And of course, as His Honour Judge Jackson decided in one reported secure accommodation case recently, some children absolutely have the right to be heard directly by the judge hearing that case, and that right is clear in the Children Act 1989, I don't think that's me, as amended by the Children Act 2004. However, leading judgments are clear that whilst the child has the right to be heard in a set of proceedings about them, how that right is exercised is a matter for the judge. And I know we've got judges in the audience tonight who are clearly far more expert than I am on this matter. And that judge has that very difficult task of striking a balance between the benefits and the burdens of the different ways in which children can engage directly with the courts. In Cafcass, we often support children to write a letter to the judge in their case, or indeed to see a judge if that is in their best interests. But it's often more important that the court hears and understands the voice of the child. Children usually want to write to the judge, hearing their case, because they are worried that they won't be heard. And of course, all too often that has been their experience to date. And my firm view is this, that all of us working in the family courts should be proxies for the voice of the child. I want to turn very briefly to this notion of sense-making, or perhaps making sense, to put it into more common sense language, which I think is crucial in relation to what children say. Because for many children, there can be a disconnect between what they say, what they feel, and what they need. In short, they are often confused, and who wouldn't be, given the suffering behind closed doors that many of them have experienced? In our work in CAFCAS, we seek to get underneath a child's words. We're trying to understand their feelings. And in order to do this, our practitioners work directly with family members in family court cases who are often beside themselves with worry, with rage, or with fear. And as you can imagine, this is very emotionally taxing work for our practitioners, as indeed is the case, I think, for social workers up and down the country. And I say this because I feel very strongly that social workers often don't receive the respect or the recognition that they deserve for the critically important and very difficult task that they do. Now, as I'm sure most of you are aware, in 2011, David Norgrove conducted a review of the family justice system. And the reasons for that review were that the system was frankly creaking under the huge strain with rising caseloads and sometimes incoherent organisation and processes. And this was causing damaging delays for children and family, sometimes taking over a year for an outcome in a care case, and with a big backlog of cases in the public law system that built to around 20,000 children waiting for their futures to be decided. The Family Justice Review made recommendations to place the voice of the child, to place the child at the centre of the court process, thereby allowing their voices to be heard. And the Children and Families Bill, which has been in progress since 2011, took forward a number of these recommendations and is currently awaiting royal assent following its very lengthy parliamentary passage in both houses. Indeed, I'm told that it's sort of waiting for the Queen to sign any day now. And just as an aside, it was a very interesting experience for me to be involved in all the work on the bill, going through the Lords. For about the last 6 months, one of the main things I've been doing is taking part and speaking at all stages of the Children and Families Bill. And it's a very big and complex bill. And in fact, the family justice section is one quite small section. There's about sort of 10 different themes. And it's changed hugely as it's gone through because of the amendments, because of the scrutiny. So it's a really interesting, but it's a big and a complex bill. I am just going to highlight very briefly two specific changes in the legislation. One is public law and the other affects private law. Firstly, the new 26-week time limit in public law cases to ensure that processes don't drag on. The mantra from the President of the Family Law Division here, I'm sure some of you have heard of it, will be talking about creating a culture of urgency rather than a culture of delay. And indeed, I used his words, although I did give him credit for it when I talked in the Lords, because I thought that was a very good way of actually saying it. And I actually think that although the legislation isn't quite on the statute book, as I say, just waiting for the Queen to sign it off, it's already had a major impact on the way that public law operates, with some really big reductions in case durations. Now, yes, absolutely, there are still some quite big local variations, and that's one of the things we do in CAFCAS, is look at these local variations. But with the introduction of the new public law outline, many new cases are already being completed, actually in well under 26 weeks. And just compare that to the average case duration of only 2 years ago, which was around 55 weeks. I mean, it really is a very big and dramatic change. And I think that happened because there was just a consensus within the family justice system that the current system was just unacceptable for children to have to wait so long. And what I think I've seen is the judiciary, local authorities and CAFCAS working actually very effectively together. Very much judge-led work, and with the local family justice boards as well. Has really made a big difference, and that's even before the legislation is formally on the statute book. In my experience, that's quite unusual, actually. You usually get something on the statute book, and then it takes quite some time for change to actually happening on the ground. The second change I just wanted to highlight affecting private law is Clause 11 of the bill, affecting co-parenting after parents separate. At the outset of the bill, ministers wanted to strengthen the law to ensure that children had a relationship with both of their parents after family separation, where of course that was safe and in the child's best interest. And Clause 11 originally came under the heading of shared parenting, and it stated that the court should, and I'm going to quote here, presume, unless the contrary is shown, that involvement of that parent in the life of the child concerned will further the child's welfare, end of quote. Now, I'm sure you know that the clause and the debate around it, sort of political and elsewhere, caused quite a lot of alarm, with many fearing that it would lead to separating parents, assuming that they were legally entitled to equal access to their children. And indeed, in Australia in 2006, where a similar legislation was introduced, the Shared Parental Responsibility Clause, 65% of fathers interpret this as equal time, and it led to a substantial rise in litigation between parents. But a lot of organisations, academics, charities and others in the family justice world argued for Clause 11 to be amended to ensure that the best interest of the child remained the paramount concern when reaching decisions about a child's upbringing. And this led to what I thought was a really important amendment to the clause at the third reading of the bill in the Lords, which clarified that the involvement of a parent in a child's life means, and I'm going to quote this again, involvement of some kind, comma, either direct or indirect, comma, but not any particular division of a child's time. And there were many of us who were very pleased to hear it spelt out, or to see it spelt out in those terms. And indeed, during the debate, my predecessor as chair, Baroness Tyler of Enfield, said, and I quote, "We should never see children as objects of concern, but as subjects in their own right. When parents haggle over children as property, it is our responsibility to ensure that their welfare is seen to." And I think the wording of this amendment now, which will go into law, does make it clear that when parents are separating, neither mother nor father is entitled to a legally binding presumption of shared contact, but rather that decisions are about focusing on the needs and interests of each individual child, rather than focusing entirely on the expectations of parents. And I'd just like to pursue now the whole issue of parental conflict. Research, as I'm sure you know, has shown that it is one of the primary risk factors for negative outcomes for children whose parents are separating. And indeed, the research makes clear that high levels of parental conflict in the presence of children threatens their sense of emotional security and really adversely affects their whole view about, families, family structures, adult relationships. Indeed, Owen and Rhodes in 2012, investigating interparental conflict using parents who were court-ordered to attend a 12-hour co-parenting intervention, came up with some interesting results. And they found that there were improvements in both of the co-parents' relationships with each other's and improved confidence in co-parenting after this particular intervention. Both men and women reported a decrease in the amount of conflict in the presence of their children. However, only women reported a decrease in the general negative communication with the co-parent. And these changes were generally maintained at a 2-month follow-up assessment. And I think these findings, and there's plenty of other research as well, suggests that interventions for high conflict co-parents can increase their ability to work together cooperatively. And relating all of this back to the child, increasing what is known in the jargon as the relationship functioning of co-parents and giving them greater confidence in their ex-partner's parenting, I think can have really highly beneficial outcomes for children. I mean, in short, parents are drawn back to acting in the child's best interests. And CAFCAS offers a range of interventions for parents going through family court proceedings, including something called the Separating Parents Intervention Programme. These programmes can be highly effective and enable parents, I think, to understand what their child is thinking and feeling to help improve the communication skills. And research and data is beginning to tell us that if this sort of programme is followed up with some more direct work, it can actually resolve disputes even in some of the most intractable family situations. And when I do my sort of visits around the country, go and talk to colleagues in CAFCAS, talk to judges and others involved in this, I've actually sat in on a couple of these sessions where Separating Families actually watched the video, Separating Families information program video. And I actually felt I saw, if you like, in some cases, sort of scales falling from their eyes for the first time in terms of realising and understanding the impact of their sort of high levels of conflict on the child. Indeed, we find that many children have never spoken about what they are going through before to anyone, not even to a friend, and that they feel, as a result, totally isolated. And I must say, when I talk to practitioners, I'm always really impressed by their ability, and I try to talk to as many practitioners across the country as I can, who manage to say a lot about a child's needs, wishes and feelings in their court reports, without, frankly, having as much professional time to carry out their work as they would wish to have. I know that is the case. It is simply a fact of life. Now, as Ravi Kohli has said, some children have what you might call a thin story, whilst others tell what's called a thick story. And a thin story is a composed version of the truth, or even sometimes a made-up story, either to deflect attention or perhaps because of the fear of the consequences of telling the truth. And a thick story is characterised as a truer version, which many children will only tell when they feel secure, which could be days, weeks or months later. And of course, and I readily acknowledge this, one dilemma about faster family justice is that whilst delays are clearly not in a child's interest, it does take some children time to talk, time to feel really confident. And for older children, I think, time to think through the options for their future. And if we are serious about basing family justice on a child's timeline, as has been up on that slide for quite some time, which I've seen you've been reading, it will need to be fast, I think, for some children, particularly for babies and young children, and perhaps more reflective for others. So I've already talked about each child being different, and certainly in our work in CAFCAS, we apply an objective analysis to each case about a child's needs. Now, sometimes parents find this painful or unhelpful. So when we carry out a child impact analysis, which addresses items such as the impact of parenting, the home environment, and the child's attachments, it often comes as a surprise to parents to understand the impact of what they've been doing to their child or children. Often they just don't know. No one perhaps has told them or helped them to understand. And of course, perhaps their own experience of being parented fell very short. I mean, after all, much neglect and abuse is intergenerational. Indeed, over 30% of parents whose children are subject to applications by a local authority to remove their child from their care have had a previous child removed from them in similar circumstances. I'm sure we've all come across cases where it's the 6th and the 7th and the 8th child being removed. And sometimes the court case itself leads to even heightened emotions and rage. And indeed, Ian made this point, I think, very clearly at the beginning. In court cases, people are often at their very worst. Some children in private law cases are coached by one parent against the other, a syndrome which is sometimes given the name of parental alienation by some commentators. or indeed was called, I believe, the recruitment of child soldiers by a leading High Court judge, Mrs. Justice Parker. And this often means that the voices of parents, one against the other, are loud, and the voices of children are silent or inaudible. And I think it is in these circumstances that we all owe it to children to speak up for them, so that their true voice has equal status. So as I hope I've made clear so far, our work is often about changing the way people think about their children. And in some of our private law casework, our practitioners see children and then meet their parents to feed back to them what their children are thinking or saying. And this has frequently actually changed the way parents think. And safe arrangements, agreements with parents about residence or contact can often be reached as a direct result. So, for example, we might ask a father who is angry with the mum's new partner whether he would rather his child be read a story before going to sleep, or whether he would rather his child was ignored. And of course it's hard, very hard, for a non-resident parent to see, let alone support, their ex-partner's new partner and see them getting close to their child or children. But such collaborative parenting can help children adapt and recover if their experience of parental separation has been traumatic. And I think yet another way of understanding the voice of the child in the family justice system is quite simple. It's to ask them. Children's feedback leaflets are available in all of our offices, and in our Cheshire and Lancashire service, young people have designed something called a secret agent feedback form, which each child in a private law dispute who comes to one of our local offices is helped to complete. This helps us ensure our work is as child inclusive and child friendly as it can be. And in 50% of forms completed between October and December 2013, children actually expressed relief or appreciation at being given the opportunity to discuss their feelings. 2/3 of older children reported a range of emotions at the beginning of their meetings with one of our practitioners, and then a more positive emotion following at the end of the interview than at the start. The percentages for younger children were slightly lower, but not by that much. But I guess it's just stating the obvious, really, if I say that children are usually the best source of information about themselves. They are, of course, experts in their own experience. I want to turn now to mediation. Because as you've probably picked up recently, there's a lot of focus on alternative ways of resolving disputes, which keep cases away from the court. And I'm going to focus today on mediation, because there's been a lot of talk and focus about it recently. So when enacted, the Children and Families Bill will actually make it compulsory for the applicant in family law proceedings to attend what's called a mediation, information and assessment meeting. And this is often the first step to mediation, designed to provide parties with information about mediation and to help both the parties and indeed the mediators determine the suitability and willingness to undertake mediation. And of course, one of these assessments includes a domestic violence screening and offers parties the opportunity to think about the advantages of mediation compared to other processes for settling disputes and making arrangements. So what exactly is mediation? I came across what I found quite a helpful definition of family mediation in the UK, which is broadly defined as a process in which an impartial third party, the mediator, assists those involved in family breakdown to make arrangements to plan for or following a separation or divorce. The process is managed by the mediator, but the content is decided by the couple. And of course, the intention of mediation is to reduce conflict and the time and costs involved by helping families reaching long-lasting agreements which are in the best interest of all involved. The scope of it can include disputes around contact arrangements, residence, parental responsibility, child maintenance, property and finance. And very recently, the then Family Justice Minister, because they do seem to turn over quite quickly, Lord McNally said, "The government strongly supports mediation, a quicker, simpler and more effective way for separating couples to agree how they divide their assets or arrange child contact, which avoids the traumatic and divisive effect of courtroom battles." Now, I recognise it won't work for everyone. I also recognise there are some very big challenges around at the moment in terms of the availability and access to high-quality mediation. Indeed, there are many voluntary organisations and others I know who are actively considering whether to get more involved in this area. But there are clear benefits where it works properly. It's clearly faster and less expensive than litigation, and as I say, can bring about longer-lasting resolution. But I think the critical thing is the parents feeling that they've had that final say in arriving at a decision, and the agreement can be more flexible and allows the mediator to refocus, I think, both parents' attention on the needs of the child, thereby ensuring that, even in mediation, their voice is heard. Indeed, in her recent research in 2011, Walker found that if mediation addresses some of the underlying tensions and barriers between high conflict parents, parental cooperation can increase for the long term, contact can be increased, and there was a greater involvement of both parents in the child's life, and also increased compliance with child support or maintenance payments. Now, I don't want to give you the idea that I'm sort of overly dewy-eyed about mediation. I've already acknowledged there are problems with the way the current mediation market works. But I know that previously it was thought that the voice of the child was often lost in mediation, instead focusing on parents' needs. Now, I think various efforts have been made recently to try to address that, and I just wanted to say a word or two about this. There are clearly various types of mediation, including child-inclusive mediation and parent-only mediation. And interestingly, some research done very recently in 2013 by Bell and others into child-inclusive mediation found that when comparing the benefits and outcomes of mediation with a child-inclusive focus and a parent-only mediation group, those in the parent-only mediation group were significantly more satisfied with the mediation and felt as though some or all of their issues had been resolved. They also believed that they had an improved relationship with their ex-partner, which they considered to be as a result of the mediation. And during that parent-only mediation, the child was seen by a child consultant, and this was generally positively received, and indeed helped to refocus the parents on the voice and needs of the child. Now, you may agree with me that initially when I read it, I thought this is a bit, counterintuitive. It was intriguing results. You might have assumed that the physical involvement of the child would actually produce more positive results. But having said that, overall, the study found that the best predictor of successful resolution was the parents' levels of acrimony, conflict and cooperation, not the presence or absence of the child during mediation. And I think the research underlines the point that mediation is definitely not the right way of resolving disputes for all parents by any means, but can be highly effective for those who are willing to cooperate, and I think that's the key thing there. I'd like to finish my remarks by saying a few words about our Young People's Board. They are now called the Young People's Board for the whole of the family justice system. But that board, and I think it's something I think Ian will agree with me, we're very proud of in CAFCAS. It was established in 2006. And actually, I think it's one of the aspects of our work that I do feel most proud of. It now has over 40 members from the age of 8 upwards, and it's very much going from strength to strength. 2 young people sit on the CAFCAS board, and again, I think Ian will bear me out when I say this, very much join in our discussions and tell me their thoughts about what's happening. 2 of them now sit on the Family Justice Board, and very recently, as a result of a discussion we had at the CAFCAS board about the impact of some of the current issues around transparency and reporting of family cases, which the children felt very strongly about and felt that actually their sort of view on this hadn't really been taken into account. We were able to arrange for them to go and see Sir James Mumby, the President of the Family Law Division, and he took very seriously indeed what they had to say. So the young people have drawn up a national charter for child-inclusive family justice, which sets out 8 children's rights, which they feel must be respected in every case and in every court. Now, copies, I know that there are copies down here because I saw them earlier, and they're definitely available, but I'm just sort of wildly looking around to see where they've They may be at the front, I don't know. I may have to... They may have been handed round. Anyway, there are definitely copies available. And CAFCAS, as I'm sure you would expect, is an early adopter of the National Charter. And the Young People's Board have recently secured the sign-up of 2 of the major agencies, partner agencies, on the Family Justice Board. And that means that those agencies will now have their own work programme to promote the voice of the child in their own organisations. And over time, I think this will help make the voice of the child in the family justice system that bit louder. And now the next stages of their work programme will come together next summer at the 2nd Voice of the Child Conference, which the Young People's Board themselves very much plan, present. We facilitated, but it's very much their event. And indeed, the first conference was held last year in Birmingham. It attracted over 300 delegates, and despite the very best efforts of Fathers for Justice to wreck it, it went ahead, and the young people were, I think, very pleased with it. Well, certainly those who attended deemed it to be a real success. So, to conclude, I have tried today to focus primarily on the voice of the child rather than the many social issues that the children we work with face, or indeed by wider aspects of the family justice system. And that's not because I don't think those wider social issues are any less important. I mean, I deal in other aspects of my work with many issues, what you might call social justice, social policy. They could, be the subject of a whole series of lectures. But if a child is in care as a result of neglect, our role in CAFCAS is to understand where that child is now at this point in time and what needs to happen to improve that individual's that child's life chances for the future. There may have been problems, of course, with the level of support that the family received, or the type of help may not have been very well targeted or delivered, and of course it is simply a reality that some of those services have been cut recently or discontinued. But our work in CAFCAS and our legal duty is to start with the child and to stay with the child. I think you can say really, or it's my view, that the child is nearly always a victim, even if his or her parents or carers are also victims in some other ways. And of all the organisations involved in family justice and social justice, it is our role to focus exclusively on the voice of the child in the situation that they find themselves in through no fault of their own. So I'm just going to end by one sort of observation, if you like, slightly philosophical maybe, but all of us bleed when we are wounded, but just as quickly as that wound opens, our body begins repair work immediately. And indeed, so it can be with children who are recovering from distress or trauma. And I think our professional task is to accelerate that repair work and to help with the healing process. Now, I didn't mean that to sound too philosophical. It's actually meant to be practical. The child's journey to adulthood, so often rudely interrupted by events that trigger either a care application by a local authority or a private law application, is a journey that we can help with by helping children to get back on their personal road, or indeed, if need be, to help them change course. And with limited time available to us, there is no time for us to do anything else. But if we do that well, we will be making an effective contribution both to children's well-being and to wider society. And that is why I am so pleased to be involved with CAFCAS and all the work that it does, and also to see the very high levels of cooperation, which I think are now mark the way the family justice system operates. Anyway, that's it. They were the issues that I wanted to cover. I'm very happy to take questions, comments, feedback.